Well, I've never met the gentleman, William Scharf. How are you, sir?
Doing great. Great to be with you, Mark. Longtime fan.
Well, I understand you're running for Attorney General of the Show Me State. Is that correct?
That's correct.
And what do we show each other in the Show Me State, or should I keep that private?
Well, I think it's an attitude. It's a way of viewing the world that we don't take things at face value. You've got to show us. And what we keep seeing over and over again is the mainstream media and the radical left. They want us to take them at face value. And as you and I know, we've got to dig deeper. So,
it's funny. I once asked Mike Pence, "What is a Hoosier?" And honestly, I stumped him. Anyway, I want to discuss this piece you had in the Federalist the other day. I read it to the nation, to the audience, and I watched this Bill Barr on TV. It's very, it's revolting, actually. And there's a couple of things you raise here that I think are very, very important. For instance, this guy Smith, the so-called special, he didn't have to bring this case now, did he?
No, there's no reason, there's no statute of limitations that required them to bring this case at the height of a presidential election. Prosecutions are never supposed to look political. They're never supposed to feel political. This feels like a political prosecution, and I just wish they'd waited until after the election was over if they were going to do something like this.
Mm-hmm. So he could have waited. I guess President Trump's lawyers could still file a motion asking the trial to be pushed till after the election, correct?
Yeah, they could move to continue the whole thing tomorrow. And it would be interesting to see how the special counsel would respond to that.
Yeah, and I think they ought to do everything they can to push that guy on his heels, don't you?
Yeah, I mean, look, his record is just, it's not a good record. The Bob McDonnell prosecution alone, where he went after, as you know, a popular former Republican governor of Virginia, and the Supreme Court threw out those convictions unanimously. So this is a guy who's, I think he's a pit bull. I think he's ideologically motivated, and they've got to do everything they can to fight back against this prosecution.
And you say that as a former assistant U.S. attorney, correct?
Yeah, I was a federal prosecutor. I also clerked for 2 federal appeals court judges, just trying to read the law and the case as I see it.
What do you make of this thing that really it's not the Presidential Records Act, but the Espionage Act that's the key? What's your takeaway from that?
Well, I think the key thing is the interplay between the two acts, Mark, that under the Espionage Act, under the section they've charged the president, they have a high bar to prove his willfulness, his knowledge. They can't just show that he had some classified documents or classified marked documents at Mar-a-Lago. They need to show a lot more than that. And based on the president's rights and his responsibilities under the Presidential Records Act, I think it's going to be very difficult for them to show that President Trump knowingly and willfully kept materials that he knew he wasn't supposed to have. That's a high bar for them to reach.
If he believes he has the right to declassify on the spot, I do too, by the way, but if that's his belief, and he believes this is covered by this other law, the Presidential Records Act, and everything's thrown together in boxes and so forth, and he resists the government demand, turn it over, turn it over, turn it over, how's that obstruction?
Right, and I think that if he thought he had the right to keep these documents, if he thought that these boxes were not something he had to turn over to NARA, the National Archives, then it's tough to make this prosecution stick under the act that they've charged him with. And on the classification point, I would just note that even if he didn't declassify these documents, that doesn't mean that they constitute national defense information under the Espionage Act, it's a different classification under the law. It's a different statutory system altogether. So the special counsel's office is trying to make this look like a rock solid case, and I see it just based on a very shaky foundation.
And they put pictures out of the boxes and how the boxes were treated, and they're making references to classified information and so forth. In addition to your last point, why else would they do that?
Well, I think that the point of this indictment, the point of the rollout, the point of Jack Smith's press conference was to prejudice the country against the president, that they know the strength or lack thereof when it comes to their case. And I think they were trying to really posture that they were coming from a position of strength. when if you actually look at the law and you actually look at the allegations, I think this is a much weaker case than Jack Smith would have the country believe.
We're talking to Will Scharf, who's running for Attorney General of Missouri, has a fantastic pedigree here. So when Bill Barr quotes Andy McCarthy, who quotes Chris Sununu or something along those lines, that if he's just convicted of half the charges, he's toast. Why do they think this is such a slam dunk case?
Well, I think it's also worth noting that Bill Barr said that it would be, I forget his exact wording, but he said it would be an outrage if President Trump was sent to prison. That would be bad for democracy. Mick Mulvaney today had an op-ed out where he said basically the same, that this case shouldn't have been brought now, that bringing this case was bad for the republic. So I would just say, from my perspective, I read the indictment, I read the law, I responded to that, and I don't see the same case that I think these guys see.
Mm-hmm. Now, let me ask you about the courtroom. I want the American people to understand this. If it ever comes down to classified documents, number one, you have a right to a public trial, correct?
Yes, sir.
Number two, how does the government intend or expect to keep every one of these documents secret from the American people? If I'm a defendant, I'm going to challenge every damn one of these documents. The classification of the document, whether I declassified the document, whether or not it's the government's property, whether or not, as you point out, it was misclassified. I'm not going to just let the government walk away with that argument. So how is that going to play out in open court?
Yeah, I think this case, starting a couple weeks from now and continuing until the day that it reaches its final judgment, final resolution, is going to be hotly contested. President Trump has a great legal team around him. Todd Blanche, who's now his lead attorney, highly accomplished attorney, really knows what he's doing. I think they're going to contest every single evidentiary issue. As you said, the classification and the privacy of these documents. I think the other big issue, and I've written about this, is attorney-client communications, other potential areas of I'd say malpractice or things the government's already done that I think in terms of misconduct that could cast doubt on the entire case. I think this is going to be hotly contested from day one, and certainly if it goes to trial, there are going to be a lot of evidentiary motions that they're going to put in front of Judge Cannon. And I think that they're going to have the right to seek to have this case framed the way they want and not the way the government wants it.
And there's going to be appeals, correct? Even interlocutory appeals if needed, don't you think?
Yeah, for sure. I mean, the same way we saw Bob McDonnell's, Jack Smith's prosecution of Bob McDonnell thrown out, by a unanimous Supreme Court. I could easily see issues here heading up to the Supreme Court as well.
Let's talk about attorney-client privilege. All that was litigated in secret. We don't know exactly what took place. We have people getting in, the crime fraud, telling us what the crime fraud exception is. Your point is, we don't need a lecture about what the crime fraud exception is. What we want to know is what was contended and what this judge ruled on, because you point out in your article, it's one thing to run by your lawyer a whole bunch of scenarios. It's another thing to actually enlist your lawyer in a criminal enterprise, right?
Yeah, two very, very different things under the law, and breaching attorney-client privilege is not something that any judge, any court should undertake lightly. Here, I think the government was hell-bent on getting Evan Corcoran, President Trump's attorney's testimony in, because they needed that to show the president's intent to make these Espionage Act charges. I think that's the same reason they attempted to exert undue pressure on Nauta, President Trump's co-defendant's lawyer, to try to get him to flip. They need somebody in the room who can speak to President Trump's state of mind. And without those attorney-client communications, as of now, I don't see that.
In fact, Will Scharf, there was another leak, a long leak. It was either the Post or the Slimes, one or the other. And laying out that they needed that attorney-client information from Corcoran, his notes and his testimony, to make the bulk of their case. So if that's thrown out, then the bulk of their case is thrown out, isn't it?
I think that's very likely. Without Corcoran, it's tough to see how they pull this thing together, particularly on the intent issues.
We're here with Will Scharf. Will Scharf will also be on Life, Liberty, and Levin on this Sunday. wanted to get more into this attorney-client privilege issue. I was saying, Will, the idea that the Attorney General would sign off on charging a former president, the leading candidate so far against his boss, in an unprecedented act where they have all the documents back, where there's no indication, even in their filing, that any of the documents were destroyed or altered or sold to the enemy or shared with the enemy. They got their documents back. The idea that they would use, in my view, a violation of attorney-client privilege, which is the source for most of this, and they would take a case of first impression. No former president, no former vice president, no former cabinet secretary has ever been charged under this statute, even though Hillary could have been theoretically. She wasn't even investigated for obstruction, even though Lyndon Johnson could have been, and so forth. And so it really is shocking to the core, is it not?
Yeah, absolutely right, Mark. You know, it feels like there were 5 or maybe even 6 or 7 different points in this case where DOJ decided to take the most radical interpretation of the law, and only by doing that at multiple different points in the investigation and their framing of the legal arguments, only by doing that were they able to string together this indictment. But it's scary for the future of our country. When you have a sitting president's Department of Justice running roughshod over normal legal practice to indict a former president who's also your boss's chief opponent for the presidency, it's really scary stuff. It's dangerous stuff.
And what do you make about all the predicates that are already there when it comes to Biden and his family? The money coming in wires to different shell corporations set up as LLCs from the communist Chinese, where you have bribes being suggested apparently in a 1023. And now we know from the whistleblower, excuse me, to Grassley, I suppose, that they have video. I go on and on and on, and yet no special counsel.
Mark, if that 1023 from Ukraine that said that Biden and his family took $5 or $10 million in return for influencing American policy and getting that prosecutor fired, if that 1023 is true, that's the greatest scandal in American history. Mm-hmm. And the fact that there hasn't been a full and complete investigation, the fact that the government is still playing games in terms of letting that information become public and letting it be publicly tested, I think is outrageous. And the fact that President Trump was indicted a day after that 1023 was finally released to members of Congress and word finally started getting out, again, it just smacks of political timing, and that's the opposite of what you would hope for in a case like this.
Mr. Producer, you have cut one there. I want to play for you, Will Scharf, running for Attorney General in the Republican primary in Missouri with my full support. Will that hurt you? I hope not. That's not my intention, obviously.
Folks in Missouri love you, Mark.
Well, thank you. Let us play for you a little back and forth between Robert Acosta of CBS and Bill Barr. Go ahead.
Do you believe that he continues to claim that he has all these privileges and rights under the Presidential Records Act? Is he mischaracterizing the act?
Absolutely. The legal theory by which he gets to take battle plans and sensitive national security information as his personal papers is absurd. It's just
so let's stop there. So, Will, my first comment there was, that's not how this works. They box up all this stuff. And he doesn't box it up. Staff does. Maybe the GSA does. They're trying to get the former president out so they can get the new president in. That's the theory. They box all this stuff up. And when they get around to looking in the boxes, they get around to looking in the boxes. They're not clerks. They're former presidents with 1,000 things to do. So, number one, that entire setup by Barr is not correct. Do you agree with me?
Couldn't agree with you more. If you look at any picture of President Trump's desk, from his time in the White House to before that in Trump Tower, you will see news clippings and pictures and signed letters, any number of just personal memorabilia, which would be personal records under the Presidential Records Act. That's what they were trying to box up. And if some other documents were mistakenly intermixed there, I don't think that reaches the level of knowingness and willfulness required to string together a prosecution under the Espionage Act.
And as a former prosecutor, you certainly wouldn't assume that or push us to that point, would you?
No, I mean, again, it's almost like a courtroom objection, objection not in evidence, that the story that's being told by the mainstream media here hasn't been proved up by the special counsel's office. I doubt if they can prove it up. And until they've shown us what they have, the president's entitled to a presumption of innocence. And this case is just a gigantic distraction from a presidential campaign. That's how I view it.
Continue, Mr. Producer. Go.
They came up with for having the vice president unilaterally determine who won the election. The whole purpose of the statute, the Presidential Records Act, was to stop presidents from taking official documents out of the White House. It was passed
No. All right. That's not the purpose of the statute. Presidents took documents out. They were personal property of the presidents, but it wasn't just to stop them from taking documents. It leaves to the president and his staff the power to segregate the documents, that which belonged to him and that which belonged to the government. So they set an entire system up here, correct?
Mark, I'm a textualist. I believe in reading the text of a statute or the text of the Constitution, and interpretation follows from there. I've read the Presidential Records Act. The Presidential Records Act sets up a system where the president can designate some records as being personal, and he retains possession of those. Even with respect to his presidential records, he retains certain rights of access to those records. It's much more complicated than this just being an act that says the president doesn't get to take anything. That's not what the statute says.
And he completely ignores that 2012 decision by Judge Jackson, who's a leftist, who's an Obama appointee, who said the president has extraordinarily broad powers under the Presidential Records Act. She would not give to Judicial Watch the information they wanted via the National Archives, these tapes or parts of these tapes that Clinton kept in his sock drawers, even though they had classified information. By the way, you're not aware that they ever used the Espionage Act against him, are you?
No, not to my knowledge.
I mean, I was thinking he and the wife could both be in prison together, given what they were doing. Now, all that said, again, the point is that you don't look... Let me ask it to you this way. If the government really was concerned and needed to get those documents, why would they impanel a grand jury, go through this long process? Why would they get a warrant? Why would they do an armed SWAT team search and all the rest of it? Why not walk into the judge's courtroom where both parties are present and take a civil track and say to the judge, I mean, I've done this before, and say to the judge, look, we view this law to say this. They have these documents over here. We need you, Your Honor, please, to put out a protective order and also order them to return us the documents in 15 business days. And then the judge does it. The other party's there. They can object whatever they want. And then the other party says, no, we're not going to give them to you. We've decided no. Then he can held them in civil contempt or criminal contempt. Why wouldn't they follow that route rather than grand jury, warrant, SWAT team? What's all that about?
Mark, I think it's a trend. It's a trend that goes back to Crossfire Hurricane and the fake Russian collusion investigation in the 2016 election. Whenever these guys, this sort of law enforcement set, look at President Trump, they always seem to take a maximalist approach, an approach intended to get him in cuffs. That's their goal. And I think that's just wrong. You mentioned the Clinton sock drawer case. It's worth noting that there you had a liberal judge looking at a case brought by Judicial Watch, a conservative organization, and she tossed it, saying that Clinton had broad discretion to designate records however he wanted. Now the shoe's on the other foot, and it's a Republican president being pursued by leftists, and suddenly the same legal commentators, the same people who would have supported Clinton back then, have completely flipped. And that's not the way the law is supposed to work.
And, well, you know who else flipped? The government.
Yeah, that's exactly
The government
right.
flipped. The government was making the arguments that Bill Barr just blows off.
And on a constitutional or key statutory issue like that, for the Department of Justice to flip its opinion, I mean, as you know, that's a big deal. Yeah. The fact that that's passed mostly without comment, I've seen Mike Davis and a few others talk about it on Twitter or on TV, but the fact that that's passed mostly without comment, I think is damning here.
It's shocking. Well, listen, it's a pleasure to meet you. Will Scharf. I'm glad you wrote that piece. Apparently, you know my stepson. I was unaware of that, but that's a great thing, too. And we'll have you on Sunday. Look forward to it.
Really looking forward to talking with you. Thanks so much for everything, Mark.
All right, take care of yourself. Guy's a sharp dude, is he not, Mr. Producer? Good, good, good.